Mr. Chair and members of the committee. My name is Jessica Daughter. I'm the Senior Chief for Legislative Policy here on behalf of all 23 elected district attorneys for the state of Colorado. We are asking for a no vote on Senate Bill number 70. To be frank, this is not a Fourth Amendment bill. Since 1961 in Colorado, and for hundreds of years prior to that for the rest of the United States and the federal courts, judges have been interpreting the Fourth Amendment right to be secure in people's homes, their persons, their papers, and their effects against unreasonable searches and seizures for probable cause, and particularly describing the place to be searched and the person who needs to be searched. But ultimately, the interpretation of the Fourth Amendment, even in Colorado, has been a balance of that need to respect the privacy of the individual versus the public interest that law enforcement has in terms of actually ensuring that safety is a primary right that we can assure ourselves of as well. So when that balance goes into play, we should be clear that the Fourth Amendment still, in all of the cases that balance those two issues, does not protect what you do in public. I'm happy to talk more about Jones and Carpenter, that there was a statement earlier that those absolutely protect against what you did in public. I want to bring out a couple of examples. Human trafficking, for one, would be a hugely impacted crime and investigation and prosecution if this bill were to pass. This committee and this General Assembly has passed multiple bills on this topic, and yet things like ALPRs, surveillance cameras, are key issues in determining when people have been taken, when they've been bought and sold in 16th Street Mall or Colfax, and this bill would absolutely restrict law enforcement's ability to get that information unless and until they get secured a warrant. I also want to bring out that there's importance in protecting collected surveillance data from hacking, but simply having law enforcement is well equipped to protect this information for privacy and security than the average person is, and preventing law enforcement from access to this very publicly available data is basically hampering those who are sworn to protect us from having access to it and protecting our streets. Thank you.
Thank you.
Thank you, Chairman Senator Weissman and members of the committee for allowing me to appear here today and testify in opposition to this bill. I want to start out by just voicing support for the idea that personal privacy is a fundamental principle that the United States social contract hinges upon, and so the discussion around that issue is important. I am Mike Allen. I'm the elected DA in the 4th Judicial District, which is the largest district in the state of Colorado. I'm also the president of CPAC, and so when I'm here speaking today, I'm speaking for all 23 elected DAs across the state of Colorado, all in opposition to this bill. The effect of this bill would allow criminals to take advantage of modern technology to plan, perpetrate, and hide criminal activity, while requiring law enforcement to work in the Stone Age, essentially. The bill would prevent cooperation between law enforcement agencies. One area that I think the committee and the legislators should consider is how to deal with task force. We have local law enforcement agents assigned to task force with federal agencies working in all manner of different investigative tasks, including motor vehicle theft, human trafficking, drug interdiction, all kinds of different things. This would prevent them from being able to work in collaboration with those agencies and share information. It's worth pointing out that, and I think Ms. Starr already talked about this, but the Fourth Amendment is not implicated in this type of information. Anything that's held in plain view is not part of the Fourth Amendment, and so things that are held in plain view, like a license plate attached to a vehicle, does not require a search warrant, and there have been many cases throughout the United States that have ruled that that type of information is plain view and is accessible to law enforcement. And I would point out at least one case. The Stout case down in my jurisdiction was a 12-year-old little boy who was killed by his stepmother. License plate readers were used to track the vehicle in Texas. The parameters of this bill would be unduly burdensome on a case like that. He went missing January 27th, 2020, and his body was not found in Pensacola, Florida until March 17th of 2020. That is 51 days. This bill would prevent access to any information that would help solve a case like that. It would prevent achieving justice for young people. Thank you.
Thank you, Clerk.
Thank you, Mr. Chair and committee members. I'm not John Walsh. I'm sorry, I'm not John Walsh. I'm Matt Kirsch. Mr. Walsh was not able to be here today because of a conflict. I am the first assistant district attorney in Denver. I've been a prosecutor for 27 years, much of that time as a federal prosecutor, but for the last year or so I've been with the Denver District Attorney's Office. I've also served as a member of Denver's Electronic Surveillance Task Force since it was constituted, and as a result I think I have a good understanding of the kinds of concerns that are motivating this bill. I have to say I don't see that this bill addresses those concerns. Instead, what I see, consistent with the testimony you've heard from the other prosecutors and law enforcement officers today, is that this bill actually has its priorities backwards. It allows warrantless searches of the information for low-level, essentially traffic and parking offenses, but it does not allow access to this information without a warrant during an investigation of the most serious crimes that we're investigating and prosecuting. Just to give you a few more examples about how that plays out in the context of crimes in Denver. Last year in Denver, there were 38 homicides that were investigated by the Denver Police Department. Of those, data from automated license plate readers was used to help solve and prosecute approximately 16 of those, 42% of those cases. In 18 of those cases, information from Halo cameras was used to help put those cases together. That stated that, based on my reading, even with the amendments proposed to this bill, would still be covered by this bill. That's about 47% of those cases. And then, this data is not useful just in homicide cases. As Ms. Daughter suggested, in our office, we've used it in addition to that to help prove cases involving sex assaults and human trafficking, aggravated robbery cases, and at least 3 cases involving violations of the Colorado's Organized Crime Act.
Thank you, sir. We have this.
Good afternoon. My name is Pedro Gamrad. I'm a senior assistant city attorney for the city of Arvada, and I am assigned to the Arvada Police Department as their police legal advisor. Within my role, I support Chief Edward Brady and Deputy Chief Todd Reeves, who are part of the executive committee for CACP, and I am here specifically in my role with the Colorado Association of Chiefs of Police. I just want to make that very clear. What a person knowingly exposes to the public is not subject to the Fourth Amendment. These are not my words. These are the words of the United States Supreme Court in the Tantamount case of Katz v. the United States. This is the case that has been perpetually cited by both Colorado state courts, the 10th Circuit, and every other court across this nation when it comes to the Fourth Amendment and an expectation of privacy. I want to read to you a portion as well from a citing case. No argument can be made that a motorist seeks to keep the information on his license plate private. The very purpose of a license plate number, like that of a vehicle identification number, is to provide identifying information to law enforcement officials and others. This comes from the 6th Circuit in the case of United States v. Ellison. You've heard testimony here this afternoon that the courts are behind and that ALPR technology is in violation of the Fourth Amendment. We disagree with that. In fact, ALPR technology has been ruled constitutional within the Fourth Amendment all across the United States, to include the 10th Circuit, specifically United States v. Matthews and United States v. Walraven. I also want to point out that the Institute of Justice was here testifying in support of this bill this afternoon. The Institute of Justice lost this exact issue in court last month in the case of Schmidt v. Norfolk out of the U.S. District Court for Virginia.
Thank you, Mr. Chairman. Question for Ms. Dotter. So I've been involved in a number of legislative proposals issued. I'd like to have district attorney support. And what I've often been told is, well, we don't take an official position on any bill unless we can get agreement of all 23 district attorneys in the state of Colorado. That's Democrats, Republicans, a whole range of political philosophies. And so what you're saying is that you have a unanimous agreement of every district attorney in this state that this bill is a bad idea.
Ms. Dodd, that's what we're holding.
Thank you, Mr. Chair. Yes, that is the case. In consulting all 23 elected district attorneys of this state, there were significant concerns about the impact, obviously, on motor vehicle thefts, which have been a huge problem for crime in this community, from homicide, from sexual assaults. When we talk about and we consider those cases, especially in sex assaults which occur, say, in lifts or Ubers, of which I know the General Assembly takes very seriously, this bill, if passed, would prevent the investigation and catching the criminals who drive those lifts and those Ubers. It would prevent the human traffickers who ferry people across county lines, across state lines, among other issues. And frankly, why the DAs and are ultimately opposed, and of course Mr. Allen and Mr. Kirsch can represent this as well, being on opposite sides of the aisle in their offices, are that district attorneys are expected, alongside law enforcement, to solve cases, to help prevent crime in the community and to eradicate it and help obtain justice when they're able to find the criminals that committed that crime. If this bill were to pass, we sincerely believe that trust from the community would be strict, and law enforcement and district attorneys who are sworn to find the truth in these situations would be, no pun intended, handcuffed by the legislature and unable to do so.
Thank you. Mr. Chairman, I do have a question for District Attorney Michael Allen. So earlier we heard testimony from some of the law enforcement folks kind of making the distinction between a lead and then an actual, reaching a level of probable cause under the Fourth Amendment, requiring a warrant, rightly so. But that helped me to sort of understand what this really all about, and I'm having trouble distinguishing. People, I think, fear the technology here, and I think the technology could be abused. Maybe it has been. It sounds like we had some witnesses it was abused, at least in one case. But I'm struggling with how this is any different than the type of review or monitoring of my license plate that goes on, or anybody's license plate. I mean, if I'm parked in front of a building where a crime has been committed and someone sees my license plate there, it might be investigated. So what is the distinction here between this advanced technology maybe and what normally goes on with routine leads and investment by law enforcement that you work with?
Yeah. Thank you, Mr. Chairman. Thank you, Senator Carson, for the question. I'll use a case as an example to hopefully answer your question. We had in Colorado Springs a motor vehicle theft where, unfortunately, a mother had started her car, put her child in the car seat, and then ran back inside to grab something, and in that short amount of time, her car was stolen, and the child was taken with the vehicle. License plate readers were used to track that vehicle, and unfortunately, the child was recovered safely within about 3 hours. The distinction here is that in her panic, and this is understandable, any parent would feel this way, she could not remember her entire license plate number. So as she's describing her car and they're asking about the license plate number, she could not provide that. And so the police department was able to put in a partial license plate with the description of the car. If under the guidelines of this bill, the law enforcement agency had to enact a search warrant. No judge is going to sign off on a search warrant that is going to allow a law enforcement agency to prod a database to look for information that is going to lead to a suspect information or location of a vehicle or something like that, because that's exactly what would happen in this case. You would have to put in partial information and then start ciphering out on your own how to prod to get to a final result. And there's no judge in the entire state of Colorado, and I would guess the entire nation, that would allow a search warrant to be carried out in such a way. So that's the difference, I think, between a lead and concrete information, I think, is what you're asking about. Hopefully that answers the question.
Okay. Thank you, Mr. Chair, and thank you, Alan, for that. I guess continuing on that case that you just gave, I kind of feel like I'm in the twilight zone because we've been talking for the 24-hour, as this bill, as I read it, is introduced, is that there's no new restrictions whatsoever on accessing ALPR data for the first 24 hours. We've now talked, the bill's amended, and that's 72 hours. My understanding is that there is no new restriction in 72 hours from the time of the incident being investigated on accessing that data. Am I wrong in my reading of that? Or help me out there?
Thank you, Mr. Chairman, and thank you, Senator, for the question. In that specific case, you're absolutely right, that would be within the timelines of this bill. But I would point back to the case that I mentioned in my opening comments, which was the Gamestep case. That case, from the point that he disappeared on January 27, 2020, until his body was found in Pensacola, Florida, mind you, that's outside the jurisdiction of the state of Colorado, and there were multiple agencies that worked on that case that would be prevented from sharing information under this bill. That included both local, state, and federal agencies that helped us locate Gamestep's body. That was a 51-day span of time. That would absolutely be outside of the 72 hours in this bill, and would absolutely have prevented us from tracking the travel of this particular defendant.
Maybe one more question on this panel. I've already, stretch time a little bit because I saw two questions, and this is a submitted panel. Mr. Vice Chair, then Mr. Records.
Thank you all for your testimony. This could be to any of the district attorney, either DA Allen or Deputy DA Kirsch or Ms. Donner. We've had some discussion about warrants and how a law enforcement entity or individual would go get a warrant. There's been some testimony that it's really easy. You can just do it in a few minutes. Can you walk us through in reality what that looks like and the implications that this policy might have on that process?
Who would like that?
I'll answer that question, Mr. Chair. Thank you for that question. In reality, the process of writing a warrant involves a law enforcement officer sitting down, usually over a matter of hours, and compiling all of the information that they have gathered to date that they think is going to be sufficient to establish to a judge that there is in fact probable cause to believe that the warrant is going to lead either to the arrest of a subject or to further admissible evidence of a crime. In our office, and I believe this is true in many other prosecution offices, after the affidavit has been drafted, it gets reviewed by one of our deputy district attorneys. They are trying to do the same kind of review that they think a judge is going to engage in and determine whether there's probable cause. In many cases, the district attorney will identify potential gaps or shortcomings in the warrant. They will communicate those back to the officer, who will fill them in if he can, send the revised affidavit back, and only after that process is completed will the affidavit be submitted to a judge.
Okay, Senator Gonzalez with the last question.
Thank you, Mr. Chair. There was testimony earlier that spoke to concerns regarding information collected by these flock cameras or license plate readers that would thereafter be accessed by other agencies and jurisdictions outside of the state of Colorado. In 2023, Colorado passed Senate Bill 188 that prohibited and ensured that Colorado law enforcement would not assist in the prosecution of people who seek abortion care in states, in Colorado, would not assist in the prosecution outside of Colorado. If Senate Bill 70 were not to pass, who in your estimation should be held to account?
Senator Gonzalez for which witnesses?
The panel?
Thank you.
Anybody who wishes to respond?
Anyone who'd like to return? Ms. Tucker.
Thank you, and thank you for the question, Senator. I think the interesting thing about Senate Bill 70 is that regardless of whether or not it passes, federal authorities, other states will have access to that information. This bill will not stop those folks from having that access to that information. And so when we're talking about who is to be held for account in other states and other jurisdictions, it does not, I don't see anything in this bill that would stop other states and other federal authorities from gaining access to the information from surveillance cameras, from publicly, privately owned cameras, from photos, from all of that. And so I don't see the connection between how Senate Bill 70 solves that instead.
Anyone else want to jump in? Go ahead, sir.
Thank you, Senator Wiseman, and thank you for the question. From the chief's perspective, information is information. How it is used is how it's used. Whether or not you have a bad actor or a good actor, it should be directed at the bad actor, not the system as a whole. If someone is misusing information, then that person should be held accountable, and we have those laws in place. This bill does not change that.
Okay, we will let this panel go at that point. Thank you all for testifying with us. Next,